Good morning. Thanks to you members of the media for accepting our invitation to attend this media conference on such an important issue. Also, good morning to members of the public who are listening to the replay of this recording. It is important for members of the public to assess the facts of this matter so that public pressure can be brought upon Angostura to have this injustice addressed and redressed. We have called you here this morning to report to the public on this matter, which has a direct impact on the rights of women in the workplace when women are sexually harassed, indecently assaulted, and have other sexual misdeeds committed against them by powerful employers and their officials. You will hear this morning that Angostura has a whistleblower policy, the aim of which is to give victims of sexual harassment at the workplace protection against reprisals and to provide a machinery for Angostura to conduct a fair and thorough investigation into the complaint. You will also hear that Angostura appointed a highly qualified investigating committee to investigate the senior employee's complaint of sexual harassment and indecent assault by a top official of Angostura. The top official refused to testify or be cross-examined by the investigating committee or attorneys at law for the senior employee. Angostura, in the middle of the investigation, terminated the investigating committee's appointment and appointed an attorney at law to prepare a report, which was then used to dismiss the victim's complaint. The question which arises is whether the women's rights organizations, the other non-governmental organizations, the public, the media, and the government ought to allow Angostura to prevent a thorough investigation into the complaint of the employee victim in this matter. The International Commission of Jurists, which is an international organization based in Geneva and is concerned with the observance of the rule of law, has stated that lawyers, in addition to discharging their professional duties and legal assistance to the best of their abilities to their clients, and in addition to lawyers taking appropriate action to protect the interests of their clients, lawyers also have a duty to take steps to promote an independent and fearless judiciary and to ensure there is proper access to justice to members of the public. The International Commission of Jurists also stated that lawyers in a society have an important duty to the general public, and they must at all times explain issues which affect the public interest so that the public would understand whether an injustice or an abuse of power or abuse of process has been committed or governments are trampling upon the rights and freedom of individuals. Mr. Ronnie Bisessa and I have been retained to act on behalf of the senior employee of Angostura. But this morning, we as lawyers are discharging the public duty which I have spoken about. We are discharging this morning not any duty to our client. We are concerned with our duty to the public because we see an injustice being done, and we regard this as an injustice to the entire public. We wish to make this point clear this morning because we see this as an issue which affects every individual in Trinidad and Tobago. I would first deal with the complaint which the employee made. In November 2016, the senior employee reported to the Chief Executive Officer of Angostura that she was sexually harassed and indecently assaulted by a top official of Angostura, and that she requested, as she was entitled to, have an investigation into her complaint. She also sought Angostura's protection against reprisal from this top official because this top official exercises omnipotent managerial and administrative powers over the operations of the company. The senior employee's complaint was lodged with Angostura's corporate secretary, and this triggered the requirement for Angostura to implement its whistleblower policy in favor of the employee. The senior employee was not identified in her complaint in order to protect her identity. This required Angostura to comply with the terms of the contract of employment. Angostura's whistleblowing policy is part of the terms and conditions of the senior employee's contract of employment. According to Article 4.4 of Angostura's whistleblower policy, Angostura's audit committee is responsible for determining the validity of the complaint and to recommend corrective action. The terms and conditions contained in Angostura's employee's handbook also constitutes terms and conditions of the contract of employment between Angostura and the senior employee. The handbook identifies sexual harassment as an unacceptable conduct and expressly maintains that Angostura has committed itself to inter alia the following, and I quote, providing a work environment supportive of productivity, dignity, self-esteem, and free of unlawful harassment. We strive towards the full development of all of our employees. The incidence of unlawful harassment undeniably hinders the accomplishment of this goal. Our value standard states that we expect high ethical standards, honesty, fairness, and trust in every aspect of our activities and relationships, both internal and external. If you believe you have been the victim of harassment or know of another employee who has, report it immediately. Employees can raise concerns or make reports without fear of reprisal. Any supervisor who becomes aware of possible harassment should promptly advise their manager or the Human Resources Department, who will handle the matter in a timely and confidential manner. End of quotation. It is clear, therefore, that according to the terms and conditions of the contract of employment between Angostura and the senior employee, sexual harassment and indecent assault by the top official against the senior employee, if proven, is unacceptable and unlawful conduct and constitutes a breach of the contract of employment between Angostura and the senior employee. By Clause 4.1 of the Angostura Whistleblower Policy, the Audit Committee is required to make a determination as to whether a reasonable basis exists for commencing an investigation, and once it concludes that an investigation is warranted, it shall take appropriate measures to implement a thorough investigation of the allegations, recognizing the principles of natural justice and good industrial relations practices. In accordance with Clause 4.1 of the Whistleblower Policy, the Audit Committee did determine that there was a reasonable basis for commencing an investigation and retained an investigating committee to carry out and complete the investigation and for it to report to Angostura. Further, by Clause 4.3 of the Whistleblower Policy, Angostura has a duty to protect the senior employee from any reprisals. Media reports. Within the last 2 weeks, the media has published statements issued by Angostura that it dismissed the allegations of sexual harassment made by the senior employee against the top official, and that Angostura, in dismissing the complaint, was carrying out its commitment to investigate the allegations based on the highest standards of professionalism and transparency in all endeavors, and that Angostura was committed to a policy of treating allegations of sexual harassment very seriously. The media statements went on to state a guarantee from Angostura that it would provide an environment to ensure that all its employees would be treated with civility, decency, respect, and dignity. It has also been reported in the media that in dismissing the complaint of the senior employee, evidence was not taken from the senior employee or the top official of the company. This is not correct, as the investigating committee took evidence from the whistleblower and other employees of the company, as I would describe later. It was also reported in the media on Tuesday, the 14th of November 2017, that Mr. Ralston Nelson, senior counsel, a former judge of the Caribbean Court of Justice, had replaced the investigating committee appointed by Angostura, which was chaired by Mrs. Diana Maharber Wyatt. It was also reported that the investigating committee, chaired by Mrs. Diana Maharber Wyatt, was crippled by a refusal of the top official to be interviewed. This also was not true. The media releases gave the impression to the public that Angostura conducted a proper investigation, and that proper investigation claimed by Angostura led to its decision to dismiss the allegations of sexual harassment against the top official, and no evidence was taken from the senior employee or the top official. That, as I stated, is not true. Angostura misled the media. And we this morning would show you that it did mislead the media. Those various media reports have not been denied by Angostura. Those media reports, however, do not reflect the true position taken by Angostura in relation to the investigation. Angostura did not conduct a proper investigation into the senior employee's complaint. Furthermore, the senior employee had given sworn evidence to the investigating committee led by Mrs. Diana Maharber Wyatt, but the top official did not. We, as attorneys at law, have a duty to the public to correct any false impressions on a matter of great public importance, because Angostura's decision in relation to the senior employee impacts upon whether sexual harassment against employees by employers are to be condoned. Angostura did not properly investigate the senior employee's complaints. Its decision to dismiss the complaint was wholly improper and constitutes a breach of the contract of employment between the senior employee and Angostura. The nature of the investigation. In the light of the releases made by Angostura to the media, and our contention that Angostura made its decision without conducting a proper investigation of the senior employee's complaint of sexual harassment and indecent assault by the top official, the following questions arise for consideration by the public in making its assessment. 1. Whether Angostura took steps to prevent a thorough investigation from being conducted by the investigating committee headed by Mrs. Diana Maharber Wyatt. 2. Whether Angostura practiced good industrial relations by the action it took in terminating the appointment of the investigating committee headed by Mrs. Diana Maharber Wyatt. 3. Whether Angostura was and is engaged in reprisals against the senior employee. And 4. Whether Angostura, in taking steps to terminate the investigation, which was being conducted by the investigating committee headed by Mrs. Diana Maharber Wyatt, contravened the provisions of Angostura's whistleblower policy and therefore contravened the terms and conditions of the senior employee's contract of employment with Angostura. I'll now deal with the investigation conducted by the investigating committee headed by Mrs. Diana Maharber Wyatt. In January 2017, Angostura appointed an investigating committee headed by Mrs. Diana Maharber Wyatt as chairperson. The investigating committee also included Dr. Annette Rahel, management consultant, and Mr. Ian Roach, attorney at law. The purpose of appointing the investigating committee was for it to investigate the senior employee's complaint pursuant to the requirement of the Whistleblower Policy, and for it to report its findings to Angostura. The investigating committee retained the firm of Nunes and Company, attorneys at law, to provide administrative and legal support for its investigation. By letter dated the 28th of January 2017, the investigating committee, through its attorneys at law, confirmed to the senior employees' attorneys at law, that is us, that 1. Angostura agreed to be bound by its whistleblower policy. 2. The membership of the investigating committee was carefully chosen based on their skills, experience, integrity, independence, and impartiality. And for these purposes, both Mrs. Diana Mahabir Wyatt and Mr. Ian Roach, who were former independent senators, hold no special allegiance or bond with the top official of Angostura. Moreover, diligent and extensive care was taken to appoint members of the investigating committee to ensure each member's independence, impartiality, skills, experience, integrity, and objectivity, which are critical components for an unbiased investigation. And 3, both the top official and the whistleblower have been requested to provide written statements to the investigating committee and to attend before the committee with their respective attorneys at law. The investigation. On the 1st of February 2017, the senior employee provided her signed statement to the investigating committee. On the 3rd of February 2017, over several hours, the senior employee gave sworn evidence to the investigating committee in support of her complaint, and she was questioned by the members of the investigating committee in relation to the written statement and the evidence she gave. On the 3rd of February 2017, 3 senior employees of Angostura also gave evidence to the investigating committee. By letter dated the 11th of February 2017, the investigating committee, through its attorneys at law, advised the senior employees' attorneys at law of a delay in the investigation because the top official of Angostura obtained an extension of time to the 20th of February 2017 to submit his written statement and to appear before the investigating committee. The top official provided his written statement to the investigating committee on or about the 21st of February 2017, denying the allegation. By letter dated the 22nd of February 2017 to the investigating committee's attorneys at law, the senior employee, through her attorneys at law, advised the investigating committee that she was prepared to be further interviewed by the investigating committee if the investigating committee felt it was necessary for her to do so in order for the investigating committee to complete its investigation. Next heading, top official elected not to give evidence. By further letter dated the 3rd of March 2017 to the investigating committee, the senior employee's attorney at law expressed concern that the top official was delaying in giving evidence to the investigating committee. The top official did not give evidence to the investigating committee, and on the 6th of March 2017, he instead filed a claim in the High Court against the members of the investigating committee and the attorney at law to the investigating committee to stop the inquiry and for the High Court to grant an injunction to restrain the committee from investigating the complaint and to prevent it from publishing its report. That case is still pending before the High Court, but no injunction was granted against the investigating committee or its members or its attorneys at law. The senior employees' attorneys at law, by letter dated the 27th of March 2017, to the investigating committee expressed concern about the attempts which were being made by the top official of Angostura to frustrate the investigation being conducted by the investigating committee. In an exchange of correspondence between the investigating committee and the senior employee agreed to give further evidence and to be cross-examined, provided that the top official also gives evidence and that he faces cross-examination by the senior employee's attorneys at law. The investigating committee, by letter dated the 8th of May 2017, gave direction that the parties have the following options. 1. The senior employee to give further evidence to the investigating committee and to be subjected to cross-examination by attorneys at law for the top official of Angostura. And 2, the top official of Angostura to give evidence to the investigating committee and to be subjected to cross-examination by the senior employees, attorneys at law, if necessary. Notwithstanding these directions and options which the parties had, the top official did not agree to give evidence, and he did not agree to subject himself to cross-examination. The senior employee, however, agreed to give further evidence, and she also agreed to subject herself to cross-examination by the attorneys at law for the top official. Several letters were written by the attorneys at law for the senior employee to the investigating committee for a date to resume the investigation. The investigating committee stated in its letter dated the 20th of July 2017 that it intended to continue its investigation, and both parties would be informed of the date for the continuation of the investigation in due course. Termination of the investigation committee. By letter dated the 8th of September 2017, the investigating committee's attorneys at law wrote to the senior employees' attorneys at law advising that the appointment of the investigating committee was terminated by Angostura's parent company, namely Angostura Holdings Limited, through its corporate secretary. The termination was by letter dated the 6th November 2017 to the investigating committee. The investigating committee's attorneys at law advised that, and I quote, prior to the date of receipt of the said termination letter, the investigating committee was in the process of preparing for the continuation of the investigation of the subject complaint, as it has always been committed to completing the investigation and preparing its report in accordance with the principles of natural justice and fairness. The appointment of Mr. Ralston Nelson as an investigating committee. By letter dated the 12th of September 2017, Mr. Ralston Nelson, Senior Counsel, advised of his appointment by Angostura Holdings Limited to complete the investigation, but did not advise of the circumstances of his appointment. He also did not refer to the whistleblower policy, which was part of the contract between the senior employee and Angostura. Mr. Nelson, instead of writing to her lawyers, wrote directly to the senior employee at her workplace. Further, in Mr. Nelson's letter dated the 12th of September, he did not seek the written consent and approval of the senior employee for his appointment. The senior employee agreed to the appointment of the investigating committee headed by Mrs. Diana Maharaj Wyatt. Moreover, Mr. Nelson did not advise the senior employee as to the procedure or methodology that it was intended to follow or to be adopted by him in conducting the investigation, and how, if at all, he intended to deal with the evidence already given by the senior employee and other employees of Angostura, since he was not present when that sworn evidence was given. In his letter dated the 12th of September 2017, Mr. Nelson did not offer any reason or explanation for the termination of the appointment of the investigating committee headed by Mrs. Diana Maharaj Wyatt, having regard to the fact that the investigating committee was very advanced in its investigation and that the senior employee was contending that the top official of Angostura was frustrating the investigation. Mr. Nelson, in his letter dated the 12th of September 2017, did not say anything how he planned to deal with the issue of the top official of Angostura being cross-examined by attorneys at law for the senior employee, particularly in the light of the fact that the senior employee had already given evidence on oath and had agreed to make herself available to be cross-examined by attorneys at law for the top official and even to be asked questions of the investigating committee. In a letter dated the 22nd of September 2017 to Mr. Nelson, the senior employee's attorneys at law challenged the legality of Mr. Nelson's appointment and advised that his purported appointment constituted, among other things, a breach of contract of the employment between the senior employee and Angostura, there has been no response from Mr. Nelson to this letter. Mr. Nelson's decision. Mr. Nelson made a decision in relation to the investigation of the senior employee's complaint without hearing the sworn evidence of the top official and without the benefit of the top official being cross-examined by the senior employee's attorneys at law. This is in the context that there was sworn evidence from the senior employee and other employees of Angostura, and the senior employee had agreed to be cross-examined by the top official's attorneys at law. He made a decision on the facts, although he was not in a position to assess the credibility and demeanor of the parties by merely reading the evidence alone. Mr. Nelson, in reality, did not, in our view, conduct an investigation into the senior employee's complaint. He merely wrote a legal opinion to Angostura based on the evidence which was already given and made findings without having the benefit of seeing and hearing the witnesses and receiving the benefit of the responses to his questions. It is an elementary principle of law that for a fact-finding tribunal to make a proper assessment of disputed factual evidence, it is important for the tribunal to see and hear the witnesses in order to make an assessment of their credibility, their demeanor, and to critically evaluate their evidence. Termination of the investigation. By letter dated the 30th of October 2017, the senior employee was informed by Angostura Holdings Limited Corporate Secretary that Angostura Board of Directors had considered and assessed a report generated by Mr. Ralston Nelson, Senior Counsel, after review of all relevant information and material generated in the course of an internal investigation, and the board at a board meeting on the 26th of October 2017 decided that the senior employee had failed to establish the allegations of sexual harassment, indecent assault, and fear of victimization made in the senior employee's complaint, and the senior employee's complaint against the top official of Angostura was dismissed. The senior employee has not received a copy of Mr. Nelson's advice or report from Mr. Nelson or from Angostura. Having regard to the various reports in the media and in relation to the investigation and publication of the decision of Angostura to dismiss the complaint, it is necessary for us as attorneys at law to state the following. The senior employee's complaint of sexual harassment was supported by the findings of a polygraph test taken by her on the 3rd of November 2016, a copy of which was supplied to Angostura. We know as a fact that since the dismissal of the senior employee's complaint, she has been the subject of reprisals by Angostura and has been forced to take sick leave because of the damage to her health and well-being. Angostura has not complied with its whistleblower policy in conducting a genuine investigation into the allegations of sexual harassment and indecent assault made by the senior employee against the top official. Angostura has not regarded the conduct of the top official as unacceptable conduct, as stated in the uncontradicted evidence on oath given by the senior employee. The whistleblower policy at clause 4.1 required Angostura to conduct a thorough investigation in accordance with the principles of natural justice and good industrial relations. The investigation, which was in fact being conducted, was terminated before it was completed, and Angostura, in effect, asked for a legal opinion from an attorney at law in respect of the incomplete investigation, when members of the investigating committee would have conducted interviews and would have heard evidence and would have been able to observe the demeanor of witnesses and would have had an opportunity to assess the credibility of the witnesses. So far, no proper reason or any reason has been given for the termination of the Wyatt Committee. The principles of law require adverse inference to be drawn against the top official of Angostura for declining and refusing to give evidence under oath, and to be cross-examined. This is a well-established principle of law which has been ignored by Angostura. I will show you that principle of law shortly. It is also a well-established principle of law which has been affirmed by the Court of Appeal of Trinidad and Tobago, the Judicial Committee of the Privy Council, and courts throughout the Commonwealth, that sworn evidence must be given more weight than unsworn evidence or no evidence. This is because sworn evidence can be subjected to cross-examination, and the tribunal, by asking questions of the witnesses, is able to make proper assessments of demeanor and credibility. It is critical in assessing the factual evidence that where the tribunal has access to evidence on oath, that assessment is more reliable than looking at the cold facts and the documents, and in law, any reasonable tribunal will place more weight on the demeanor and credibility of the witnesses, having seen and heard the witnesses. Angostura's decision to terminate the appointment of the Diana Mahabir Wyatt Investigating Committee and instead to have a report or advice prepared by Mr. Nelson constitutes unfairness, which also amounted to a breach of the rules of natural justice. The omission and a refusal of Mr. Nelson to give reasons to the senior employee for his decision also violates the rules of natural justice. Because of the importance of this matter, I have decided to state the cases and the principles that I've just talked about. In High Court Action number 434 of 2001, between Sharon Abdul and B&L Insurance Company Limited, the leading authority of cross on evidence, and a case of O'Donnell and Richard, the legal principle is stated that where a party, without explanation, fails to give evidence when he might reasonably be expected to give evidence, but nevertheless decides not to give evidence, it is open to the court or to the tribunal to draw an adverse inference against that party and to infer that if he gave evidence, it would not have helped his case. This principle of adverse inferences was also recognized in this case of Wisniewski and the Central Manchester Health Authority, in which the Court of Appeal of England decided that in certain circumstances, a court or tribunal is entitled to draw adverse inferences from the absence or silence of a party who might be expected to give evidence on material evidence, which is an issue in a matter, and he refuses to give such evidence. The court or tribunal also in such circumstances may draw the inference that his failure to give evidence would strengthen the evidence adduced in the matter against him and would weaken any evidence which that party gives in the case. So you would see, based on the legal principles, it is curious to say the least, how it is that Mr. Nelson would not have drawn adverse inferences against a top official, and how it is that Mr. Nelson decided that or recommended that the complaint of the whistleblower ought to be dismissed. I want to also give to you some principles relating to demeanor of a witness. And this has come from the highest court of the land, the Privy Council, and the case from Trinidad and Tobago. The name of the case is the Attorney General of Trinidad and Tobago and Sam Lal, trading as a tile shop. The Judicial Committee of the Privy Council stated that a tribunal must check its impression on the subject of demeanor by a critical examination of the whole of the evidence, and must take advantage of having heard and seen the witnesses as part of a balancing exercise in order to determine whether the witness is speaking the truth. The Privy Council stated this was the very essence of the judicial function. How it is that Mr. Nelson could have assessed evidence and who was speaking the truth in this matter if he did not have all the evidence and if he did not see and hear the persons give evidence. Based on these principles of law as decided by the Privy Council, which is the highest court in Trinidad and Tobago, it is more curious to understand how Mr. Nelson, even in reviewing the evidence already given, would not have been able to determine that the evidence given on oath by the whistleblower had to be preferred against the non-evidence of the top official of the company. Rules of natural justice. In a famous case from Trinidad and Tobago, Anamontudo versus the OWTU, the Privy Council in the 1960s decided that it was an important rule of the common law that a tribunal which had to make a decision to affect the rights or interests of an individual must observe the rules of natural justice and give to the person against whom an allegation is made an opportunity of being heard. It also decided where a decision is to be made which would adversely affect the interests of an individual in the matter before the tribunal must act fairly. In applying these principles to the facts of this case, it is difficult to understand why Mr. Nelson, in the circumstances, made a decision adverse to the whistleblower without consulting her or without hearing her. Conclusion. It is our view that this matter is not only important for the senior employee, but for all victims of sexual harassment and indecent assault at the workplace. And the investigation carried out by Angostura should not be seen or used as a precedent as to how similar investigations ought to be carried out in the future. The senior employee is entitled to have a complaint properly and fairly investigated. A grave injustice has been done to her, and the injustice ought not to be allowed to continue. We call upon Angostura to reinstate the senior employee's complaint, to reject the report of Mr. Nelson, and to direct that the Diana Mahabir Wyatt investigation continue, and upon completion of its investigation, it delivers a report to Angostura. Angostura is a public company listed on the stock exchange, which is under the control of the government of Trinidad and Tobago. The government has a duty to intervene and to demonstrate that it values the rights of women not to be sexually harassed and assaulted at the workplace. We therefore call upon the Prime Minister of Trinidad and Tobago, as head of the Cabinet, to take appropriate steps to ensure that the investigation which was in progress when it was terminated by Angostura resume its hearing so that the whistleblower's complaint can be thoroughly investigated. It must be in the interests of the government and the duty of the government for the government to know whether there is at Angostura a top official who has been engaged in sexually harassing women and indecently assaulting them. Thank you very much. Any questions you may want to ask?
Boycott of Angostura products. Would you support that move, and how effective do you think this is going to be?
I would prefer boycott, and steps like that are always important in fighting a public battle. But I would prefer to see that this investigating committee continues its work, and if it does not continue its work, that some other independent committee be established. But this investigating committee has done a lot of work, and there is no basis for that investigator not to continue its work and for that work to be continued. No one can doubt the capabilities, the independence, the competence, and the knowledge and the skill of Mrs. Diana Wyatt. Nobody. As a matter of fact, I worked with her when I was in the Parliament, and there can be no doubt that she was the most competent person, most appropriate person to head such an investigation. And therefore, I would say not only an injustice was done to this lady, to the public, but an injustice was then done to that committee. And the Cabinet of Trinidad and Tobago, the Prime Minister and the Cabinet, has a duty to the public of Trinidad and Tobago to see that this is corrected.
Mr. Maharaj, if the investigation is not resumed, what happens then, from your point of view?
Well, we have certain legal options, which we will have to explore. But we do not see why the court's time have to be engaged in this and more delay would occur. And that if these allegations are true and can be proven, then it is not in the public interest and in Angostura's interest and the government's interest to have the top official at Angostura. So any delay is going to be on the side of the top official. Any delay would be greater injustice to the whistleblower. So this is a matter which must be dealt with urgently.
Is Angostura obligated to listen to your call for them to reinstate the investigator?
Yes, Angostura has the power to say they have reconsidered this matter and that they have decided that in the public interest, in the interest of the company, in the interest of the whistleblower policy it has, because otherwise it's a mockery of the whistleblower policy. In the interest of that, it can reinstate the committee, reinstate the complaint, and direct that the committee complete its report. Reject. It could reconsider Mr. Nelson's report and reject it.
Mr. Maharaj, you're saying it's a matter of urgency, but have you set a time frame that you think that the committee should continue the investigation and for the senior inquiry to be released?
Well, we have called this press conference today so that the public would know what has happened, because I think the public was shortchanged because of the release from Angostura. We believe that Angostura should act within the next 2 weeks, and that the government should act within the next week or two also. And therefore we believe that within the next 21 days we should see the committee back in action. If that does not happen, we'll have to consider our legal options, but that has to be our last resort. I want you to understand the seriousness of this, This is where a top company in Trinidad and Tobago has a policy. The policy is that women are not to be sexually harassed at the workplace. This is a case where there was a complaint. The company found that the complaint had sufficient basis to be investigated. They found that it was sufficient to appoint a high-power committee to investigate that complaint. The lady gave evidence. Other people gave evidence. The top official refused to give evidence. He tried to stop the investigation. And then what happened? Angostura stopped the investigating committee and appointed a lawyer we conducted no investigation. This is unacceptable. If this is allowed to continue, or if this is a precedent for companies, of how companies are to behave with such policy, then the rights of women would not be protected in Trinidad and Tobago at the workplace. This is a matter for every trade union movement to pick up. Every chamber of commerce. Every political party.
You're disappointed that you're not seeing that kind of support?
Well, in fairness to them, they haven't had all the facts. I'm hoping that with these facts that come out, which they can check, Angostura could come out and deny these facts. Let them produce evidence to deny it. But this cannot go on like this. It cannot. I am not prepared, or we are not prepared, to allow Angostura to get away with this. It's a gross travesty of justice. Yes, Angostura is powerful. We know that it's powerful. We know probably the top official is powerful. I understand from what I'm hearing that the top official has big people in the government supporting him and protecting him. The government has an opportunity now to show that that is not true. And therefore, I am calling on the Prime Minister as head of the government to act.
Mr. Maharaj, should the top official resign his job, would that be enough for you?
But not for me, but based on what I've seen, I am very surprised he's still in Angostura. I cannot understand why he's still there. And I don't want to say anything more, but I think the government would know. The government can get the history of this top official. I want to be very responsible, and I keep it as that.
When you say they can get a history, are you willing to provide some of the evidence?
No, that's not my duty today. I think the government is in a better position than I am in. This is a government control company. They have access to all the information. And they,
from the suggestions that you are making there, Mr. Maharaj, it appears to the level-headed person that there might be some other things in the water that they tested.
but there may be. There may be. There may be. There are matters which have been given to me which are private and confidential. I cannot say them, but I am telling you, based on what I've seen, I'm surprised that that person is still in Angostura.
So therefore you are confirming that there are other things in the water.
I think so. Anything else, ladies and gentlemen? I must thank you very much for coming.